Part 2, the transcript reading of the court hearing between the United States of America versus Paul J. Manafort, the special counsel prosecutors in Alexandria, Virginia, in front of the Honorable Judge T.S. Ellis III, page 9. Court. Well, it didn't lead to that. It was given to you by the Department of Justice. The investigation was already well underway going back to 2005. Am I correct? Well, I think, Your Honor, the investigation has developed considerably with the special counsel. Wasn't it already in existence in the Department of Justice, and they gave it to you when you all were appointed? Dreeben. There were investigations that were in existence, yes, but those investigations were folded together with our overall examination of Mr. Manafort's conduct that fits within the B, parentheses, B, parentheses, small I. All right, you have it in front of you. All right, do you have it in front of you? Yes, all right. I think you would agree that the indictment that we have before the court is not triggered by the I, which says any links and or coordination between the Russian government and individuals associated with the campaign of President Donald Trump, bank fraud in 2005, and other things that have nothing whatsoever to do with that. So then you go to number 2. It says, any matters that arose or may arise directly from the investigation. Well, this indictment didn't arise from your investigation. It arose from a pre-existing investigation, even assuming that the II is a valid delegation because it's open-ended. Go ahead, sir. I would like to take a different look at the way this order works than Your Honor's description for a couple of reasons. All right. First is that that in provision C, which is in the order, the special counsel is authorized to prosecute matters that arose from the investigation that is described earlier in the preamble and in the BI and BII. So you are not limited in our prosecution authority to crimes that would fit within the precise description that was issued in the public order. If the investigation is valid, the crimes that arose from the investigation are within the special counsel's authority to prosecute. Even though it didn't arise from your investigation, it arose from a pre-existing investigation? Well, the investigation was inherited by the special counsel. That's right, but your argument says even though the investigation was really done by the Justice Department, handed to you, and then you're now using it as I indicated before, as a means of persuading Mr. Manafort to provide information. It's vernacular, by the way. I've been here a long time. The vernacular is to sing. That's what prosecutors use. But what you've got to be careful of is they may not just sing. They may also compose. I can see a few veteran defense counselors here, and they have spent a good deal of time in this courtroom trying to persuade a jury that there wasn't singing. There was composing going on. But in any event, finish up this point, and then I'll come back to the defendant. Mr. Dreeben? Well, Your Honor, we are the Justice Department. We are not separate from the Justice Department. The acting Attorney General appointed us to complete the investigation and to conduct the investigation that's described in this order. In addition, the acting Attorney General has made clear the testimony before the Congress that this order does not reflect the details of the matters that were assigned to us for investigation. And the word arose from that's contained in the B is not full and complete description. That's meant to be judicially enforceable of the matters that were entrusted. So it's written by lawyers, but not intended to be judicially enforceable. It's certainly not intended to be judicially. Oh, I think you're better off arguing that it's very broad and that the matters that are here are well within it. But to say that you can write a letter delegating a job to somebody but don't pay any attention to the scope of it is not very persuasive, to say the least. Well, what we don't want in this country is we don't want anyone with unfettered power. We don't want federal judges with unfettered power. We don't want elected officials with unfettered power. We don't want anybody, including the President of the United States, nobody to have unfettered power. So it's unlikely you're going to persuade me that the special prosecutor has unlimited powers to do anything he or she wants. By the way, your office was appointed, you say, in May 2017. Is there any requirement that you make reports periodically to the Attorney General? Yes. Does that include financial? I think you were given a $10 million to begin with. We have proposed a budget and had a budget approved of $10 million. I believe that's correct. Have you spent that yet? I'm not in a position to talk about what our budget is. Are you in a position to tell me when the investigation will be over? I'm not, Your Honor. All right. Well, I understand that, and it's pertinent. Your Honor. All right. Well, I understand that, and it isn't pertinent to what I have to decide today. And I understand you're not being in a position to tell me, but I'm sure you're sensitive to the fact that the American people feel pretty strongly about no one having unfettered power. We had an interesting judicial conference in the early 90s, I think, on the special prosecutor, and they all appeared. I think it was at the Greenbrier. I was the chair of the judicial conference. It was a very interesting time. There were many special prosecutors who appeared, including my former constitutional law professor, Archie Cox, and others. So I had a wonderful opportunity to meet and speak to them and hear their variety of views. All right. I think you answered my questions, Mr. Dreeben. If you want to say anything else, now, of course, you're going to have a full opportunity to respond to the defendant's arguments, but I had some preliminary questions which I think you've answered, Mr. Dreeben. I think I should clarify one thing, Your Honor. We are not operating with unfettered power. We're operating within a framework of regulations that contemplate regular reporting to the acting Attorney General, who is supervising the work of the office within the framework of... Is that Rosenstein? Yes. Is he not recused? No. He is the acting Attorney General who appointed the special counsel and who is operating in the framework of the Internal Department of the Justice regulations. This is not the Independent Counsel Act that Your Honor was referring to in the conference that you spoke of. This is not a separate court-appointed prosecutor who's operating under statutory independence. We are within the Department of Justice. We're being supervised by the acting Attorney General, who has conferred upon us specific jurisdiction and who regularly is in a position to describe to us the metis and bounds of that. There is in this record a memorandum that he has issued on August 2nd that explains the crimes that arose from Mr. Manafort's receipt of payments from Ukraine is within a jurisdiction and was at... Yes, I have that right here, and I'm glad you raised it because 75% of it is blocked out, redacted. Why don't I have a full copy of it? Mr. Dreeben, well, the only paragraphs that are pertinent to Mr. Manafort are the ones that are contained in this record. Well, let me use a phrase that I'm fond of, that I used to use with my children. I can't use it with my wife, but I'll be the judge of whether it relates to the others. I think you should give me under seal to be sure, and you can do it ex parte if you wish. under seal, ex parte, a complete copy of the August 2nd, and I'll be the judge of whether it has anything to do with Mr. Manafort. Mr. Dreeben. Your Honor, if I could ask leave to consult with the relevant components of the intelligence community, because that is a classified document. Yes, of course, you may do that. If any part of it is classified, it won't surprise you to know that a district judge is fully cleared. In fact, I have several espionage trials underway. If CIPA is needed, you will invoke it and use it. But I don't think it will be necessary. I just want to be sure I understand it fully. What you're telling me is that the redacted portions don't have anything to do with Manafort or the issue he's raised. I don't have any reason to doubt, especially because you're making it, in effect, a representation. But I'm not bound by that. I need to satisfy myself. That's why I want to know. I think it's perfectly appropriate for you to consult with other parts of the government, particularly intelligence agencies. If they feel some of it is classified, I'm prepared to look at it ex parte under seal. We've got a skiff downstairs where we can put those things. So I'm fully familiar with that. You may take some time too. You can have 2 weeks to explore that. Now, thank you. Do you have anything else at this time, Mr. Dreeben? I just wanted to connect the dots with my reference to the August 2nd scope memorandum even if Your Honor is not satisfied that on the face of the May 17th order, the charges in this indictment are within the scope of the special counsel, the August 2nd memorandum confirms the acting Attorney General's understanding both at the time of our appointment and as of the time of the memo, that these crimes are within the scope of our authority, and the explanation for the greater detail in the August 2nd memo is that the public order was not the place or occasion to provide details about the matter that the special counsel was to investigate. So we are not operating off the range of what the acting Attorney General has authorized us to do. I would respectfully submit that under the Fourth Circuit law, the regulation that Mr. Manafort is relying is not a judicially enforceable matter. I understand Your Honor's view on that. I think we have provided case law on why we don't think it's a matter for the judicial enforcement. Even if the court does, we do have written confirmation that the matter and the indictment are within the scope. Thank you, Your Honor. Thank you. All right. I've actually heard probably most of their argument, and I haven't heard all of yours. You may now tell me what you think, Mr. Downey. Well, Mr. Downey is Paul Manafort's attorney. I'll bring this up in the next video.